swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Can you state your name and address for the record?
Nicole Ayers, A-Y-E-R-S.
And I pronounced your name incorrectly.
That's okay. 18 Fairview Avenue. Okay, it's not my maiden name, that was Melissa, you would have a field day. So I tried to organize my thoughts here, so at least I didn't take up too much time and I can accurately express what I'm trying to get across. I lived in Clinton for 15 years now, and I've seen the community and how great it is. I've seen how we've all come together to help the community and all of the residents here, all of the businesses here. I was one of many volunteers that helped the art museum squeegee out from multiple floods. So you can understand my concern when we're going to take away some of the flood mitigation by paving over some land that will help with the drainage of the water that goes downtown. So first off, a couple points I want to make are about flooding. Nothing stops water. Water just goes. It has a mind of its own. It's going to go where it wants, and it's going to move anything in its way. That's just the long and short of it. Retention ponds, detention ponds, whatever you want to call them, they help, but only when the amount or the size is accurate to the current flood maps. Why are we grandfathering in a development that is going to have profound effects on the flooding of this town to old, antiquated flood maps? It makes no sense. This is something that needs to be changed. That art museum, I wish you people could have seen the amount of mud and water and damage to that building from the flooding that happened. I was speechless. It was unreal how much had to be cleaned up. Wastewater runoff. You're gonna have wastewater runoff. You're gonna have, rainwater runoff. You're gonna have all of that. Where is that all gonna go? That's all gonna go into the Raritan now, because it doesn't have any land to drain into. That land up there is a natural drainage. It's a natural filter for the land around it. That's the reason why Clinton hasn't flooded worse in the past. When we pave over all of that with impenetrable surfaces, we reduce the amount of soaking in that water is allowed to have. That water will go nowhere but right down Main Street and right into the buildings and the businesses that keep this community and this town flourishing. The residents that live in these areas that are prone to flooding have had to carry their children out of their homes because of this flooding. One way we can reduce the impenetrable surfaces is to get rid of the 3 commercial properties that are slated for development and leave it as grassland, leave it as open space. Don't put impenetrable surfaces there. If you cared about this community that you're coming in to do business in, you would think about how it would affect the community and the people who live in it. Next point, traffic. I live on Fairview Avenue. I am a block and a half from where you want to build. There are 15 children within a block and a half radius from George's Place and 31 Interstate. And that was only off the top of my head. I'm sure there's babies I didn't even know about. So what are we gonna do? We're gonna put more development there for people to now speed down George's Place, to go to town, and possibly hit my kid or another person's kid? because they want to get to town? That is just, you're not taking into consideration any of that. On top of that traffic coming into town, what about the traffic of people wanting to get out of town? What happens when 78's backed up and they want to go out and around? What happens when people are leaving for work in the morning and there's somebody flying out of the Quick Check gas station? Who's going to tell that mother or that father or that husband or wife that their spouse or their parent or daughter just got broadsided on 31 because of people flying up an acceleration lane? Our schools are already overfilling. Clinton Public is not a big school. What kind of increase in children are we going to see from these townhomes? What kind of taxing is that going to put on the school resources that my family directly benefits with a neurodivergent child? What is that going to do for her access to proper care, proper education, and proper case management in the school? With all of these other kids that are going to be coming in from the counties that are going to be built. One of the things we can do to mitigate the risks is close George's Place. But that's not going to solve it all. They're going to go down one more block and they're still going to fly up the street. Infrastructure. What type of impact are we going to see on the infrastructure of this town? The sewer lines. They just had to upgrade one. The water lines. We already have an issue with water flow in this town. What is adding this going to do? And who's going to pay for upgrades so the infrastructure can handle the increase in 3 commercial properties and 56 townhomes with God only knows how many people living in them, because there's not going to be any restrictions to that. People are going to own them. Sinkholes. We had, yeah, you guys had a survey done. Awesome, great. Very small sampling from a very large property. What are we going to do to mitigate the risk of sinkholes? You can't. You don't know when it's going to happen. This land is prone to sinkholes. What is that going to do to the properties around it? The historical homes on Center Street. On top of that, blasting. Those homes, those foundations are going to crack. You guys blast, those foundations are going to crack. I'm putting a $170,000 addition on my house, my cinder block house. You blast, who's repairing my home? Because I'm not. Who's inspecting the homes before you blast? Is it somebody chosen by the developer or somebody chosen by the town? How do we know those are going to be accurate and fair and truthful assessments of a before picture of what our homes and foundations look like? We've had a lot of talk about bald eagles. There's now 2 bald eagles nests. What does that second nest do to the building envelope of the property? The building timelines of the property. On top of that, how many other wildlife species live in that area? I'm not a wildlife expert, I'm a biologist. I'm a scientist, I work in pharma. I don't know all the wildlife that lives in the area, but I can tell you that there's deer, there's fox, there's turtles, there's fish in the river. All of this will be impacted by what you guys want to do. And you know where they're going to go? They're going to go into backyards. They're going to go into private properties. They're going to burrow into houses. And on top of that, you're putting a fast food restaurant 50 feet from a property line. What is going to happen when rats start going into the dumpsters? And then they drag that food off into somebody's backyard, and that backyard has a child playing in it. And that rat goes after a child. Or that raccoon goes after a child. 50 feet from property. Why haven't we looked at a reassessment or a redraw that allows for more space between the property lines of these commercial buildings, if they must be built, and property lines of residential homes. If you cared about the community you're looking to build in, you would actually care about what it would do to affect their lives. Developers be held to the same status or same agreements that are being determined here. When it comes to landscaping, my friend met with one of the developers and discussed landscaping and what kind of brushes and shrubs and trees she wanted in her to line her back property 50 feet from a dumpster for a Taco Bell. What makes us know, what reassurance do we have that Taco Bell won't come in, buy the property after it's developed or it's subdivided, and then tear all of that out and put whatever they want? What reassurances do we have that you'll be true to your word to make sure that she has the line of sight that she wants? How much sense does it make to put 3 commercial properties on that? On a southbound lane on Route 31, going towards a highway. There are 4 gas stations within a quarter mile of 4. Why do we need a 5th? Especially in the proximity it is to the Raritan River and the environmental impacts it'll have. Sure, you have your protections, all of your gas canisters are going to be in the proper lines, basins and double protection, and those are only as good as the credentials that are set at that time. They're only as good as the restrictions that are in place at that time. And if we're working off of antiquated flood mapping, how do we know those basins will properly hold any leakage that comes from the gas basins, the whatever holds gas? How do we know that? We don't. You're working off of old flood maps. What guarantee does this community have that you will hold true to your word to build the affordable housing and not totally screw us? You build it. What makes us know? What gives this town and this committee a reassurance that you're gonna stick to what you say? Or are we gonna be stuck with a half-built construction site? Are we gonna be stuck with open land with pipes sticking out of it for years and years, like across 31 on 31 North? We don't. You have shown us nothing. You have given nothing. What about the other 2? You have nothing. If anything, we're gonna be stuck with the Taco Bell and 2 empty sites. That seems to be everything I had in terms of, opposition. One comment that's more personal than anything, and I'll leave it at this. I sat in the back of this room last meeting, and I watched you, Mr. O'Leary, and you, I forget your name, my apologies, not look one person in the eye, complete disregard, complete disrespect for the people that were speaking, for the people that wanted their voices heard for what was going to happen in their community. You're doing it again tonight. And I'm the first person that speaks. You've disrespected this community, these people, the history. And you want to come in here and build. And you expect us to just open the door and let you in. That's a really ridiculous expectation. at this point. If you want to do this, if you want to build in this property, come in here and show us some respect. Show this town respect, show these people respect, show this community respect. Make sure it works for you and for us. Not just to put money in your pocket so you can pass it down to your kids because you can't take it with you. It's all about the almighty dollar. Let's look about what this will do to a community. Let's look about this, what this will do to the residents of Clayton. Because what you're proposing is not going to do anything but hurt them.
Rick Woodman, 46 Central Street. I lived there over 13 years. I was brought...
Mr. Woodman, can you raise your right hand? Do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Of course.
Thank you.
I was brought here 22 years ago by J&J. They allowed me 6 months to go all over New Jersey and decide where I was living. I was here from Canada. I didn't even know Clinton existed. The only person I knew was Jerry, the lingual driver. And he remained a good friend for many years. What I loved most about Clinton, and I don't think has been emphasized enough, is the historic value of Clinton. History is like the environment. It's fragile, but invaluable. This development has zero historic value, zero. And in fact, I predict that the gas station will be gone in 15 years. We'll be all driving electric cars, close to electric guitars. And Taco Bell's is just going to be another one of those empty fast food diners that are going out of the business afterwards. But I have not heard anything about how it will continue to contribute to the historic value of Clinton, which is why I came here, and which adds value, I'm sure, for almost everyone in this town. And I think that that can't be measured. I've been to several of these meetings, and that's never really quantitated. It can't be quantitated, but we all know it has presence and value in this town. And I think we run a real risk of destroying that, and it's fragile. It's going to be damaged, and we won't get it back. And so I plead to the town council to seriously consider the impact historically that this decision will have. I was at a meeting 4 years ago in the town offices building. And at that time, it was a different town council, but some of the same membership. I emphasized to you at that time, your legacy will be decided by this decision. And it'll go on much longer than this development will be in existence. So again, town council, you have tremendous responsibility. Please consider the history of Clinton.
Daniela Johnson, Johnnson, 17 Water Street.
Do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
My husband and I moved here 27 years ago, and he was working in New York City at the time. We looked around the New York City area for places to live, but it was just too congested going out 78 West. Well, we found Clinton, and it was like stepping back in time, this beautiful, historic, quaint, small town, and we settled here and have enjoyed the 27 years we've been here, seen a lot of changes. Makes me kind of sad thinking that we would have a Taco Bell, because one of the things that we like about living out here is having mom and pop places to eat and shop. And whenever we go anywhere and we do see the fast food places, we're always so relieved to get back to Clinton when we get away from all of that. But my focus on my comments tonight is a little more personal. I'm mainly concerned about the flooding impact, and the state of the water that's in back of our house. We live in, I guess I call it a backwater. The river flows and we have a little area that comes up behind our houses. 17 Water Street, we live on the riverside of the street. And we've noticed a lot of changes back there. From the deck stairs to the river's edge is about 160 feet on a normal day. Our backyard gets shorter and shorter with the more rainwater that we see. And it especially changed after the removal of the trees on the other side of the river, and the buildup of the berm. So since then, we have more flooding. The river's edge used to come up about maybe 30, 40 feet. It never caused us any concern at that time. Now it's more like 50, 60 feet. When it starts getting higher than 60 feet, that's when we get a little nervous. I really dread seeing a forecast with 2 or more days of rain because I worry about how high the river is going to come up. So as I said, we have about 160 feet between our deck stairs and the river's edge. And the river has come up that high when we've had hurricanes. But on December 18th and December 28th of 2023, and then again on January 10th of this year, the river came up that high. And there was no hurricane that caused that. That was just several days of rain. Now, when the river floods, the springs that all of our houses were built on come up. That's the water that we get in our basements. So granted, it's clean water, much better than the muddy river water, but it's still water. It causes damage in the basement. We have to clean all that out. All of our appliances have to be up on cinder blocks. We've learned that there's a difference with the quality of storage containers. The ones you get up at Walmart, water can still seep through. So over the years, we've had to replace those storage containers because we've lost a lot of things that can't be replaced, like appliances can be. But we've also noticed in the last year or two that after the river does recede, the backyard is still very spongy. The puddles that had been created are still there. We let our dogs out back, and they really don't like not being able to run out back when the river is there, and they're very anxious to get back out once the river's receded. But it takes a good week now before the ground is dry and more solid, which means we have to have towels by the back door all the time because they are just a muddy mess when they come back in. Not to mention, with all that water closer to our house, that means more geese coming closer to our house, which means more droppings. And if the dogs haven't eaten it, they're stepping in it. So it's just a big mess. I'm sorry, I want to make sure that I don't forget anything that I wrote down. Anyway, so yeah, we just have to wear rain boots now when we go out back after the rain because it takes so long for the ground to dry up. There's a lot of dead ash trees along the river's edge, but unfortunately, they're not going anywhere. It's the healthy catawba trees that are starting to fall over because we've had so much water, and it takes so long for it to recede. So the catawba trees are now starting to fall over. They're of course taking dirt around with them, and they're falling into the river. Our flood insurance, when we first moved here, it was a little under $500. We just got the new bill last week. It's now up to a little over $1,500. So I'm concerned about the price of the flood insurance that we have to pay. And this is without us ever having filed a claim because of course all of our damage has been under our deductible. When we first moved here, of course we had to buy a canoe. I mean, we're living on the river, so had to get a canoe. My husband used to push us off. He would step into the water. It was a good couple of feet down, clear. We could see the bottom of the river. But over the years that changed, and after that berm was built, now there's just so much sludge back there. And so my husband would try to push us off, and he would get stuck in the muck. And then when we tried to use the canoe paddles, it got to the point where we just couldn't move because the canoe paddles would get stuck in all that muck. The last tip of green back there, lily pads, other plantings, all sorts of algae, is just like a solid carpet, and we can no longer take our canoe from the backyard. I think all of that, I'm not a scientist, I think that has to do with all the chemicals that are put in all the lawns and are ending up in the river water. So we're really concerned about what kind of impact that's going to have on us. Is that going to make the flooding worse? So we're really worried about having all these lawns up there and what they're going to be dumping into the river. My fear is that the flooding is going to be more frequent. It might get beyond the 160 feet that we've been worried about. And then what's going to happen to our basement? Are we going to have to completely empty it out? Yeah, unfortunately with old houses, they're quirky, they've got lots of charm, but they don't have a lot of room. So you really have to count on having your basement. I'm also concerned about the serenity you experience when you're on the river in Clinton. Now granted, the South Branch does go under the bridge on 31, but when you're over by the Moebus track, you see the wildlife and you don't hear the traffic from 31. And it's one of those peaceful locations to canoe over to. So I really don't want to see houses and commercial structures there. And I'm worried about what kind of impact it will have on the wildlife. We're seeing less and less of it anyway. But I'm concerned that it's just going to get, it's going to make a change in the wildlife and we're going to see less of them. So on a personal level, those are my concerns, and I appreciate your time.
Valenza Masonai Malichi, M-A-L-I-Q-I, 4 East Main Street. Hi, everyone.
You sure that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, thank you. Hi again. I am from Lebanon Borough. I've lived there for 13 years. I purchased property on Main Street, Clinton, with the dream. Prior to moving to Lebanon Borough, I lived in Somerset County. Prior to that, I was born in Yugoslav in Kosovo as an Albanian under communism. Came to the United States when I was 13. My parents brought me to the Bronx. My dad's dream was that he would bring my brother and I to New Jersey, where it was safe for him and I. We were teenagers, and someday our children. For all these years, I have worked very hard to make sure that my children live the American dream, and myself too. Unfortunately, my dad passed away. He never got to live the American dream. I come from a village, very small village, where everybody takes care of everybody else. And there is none of this gibberish. There was a lot of turmoil, but the turmoil came from way above. It was communism. I am also a divorced ethnic woman. I divorced my ethnic husband. For 8 years, I did 3 jobs to save some money to build on my dream. Now I do 2 jobs to continue my dream. I am not very thrilled with the school where my child goes to, CPS. And all of this noise does not make me comfortable about where I'm investing and what I'm doing. I only see two familiar faces here. It's the mayor and Chess. And I looked around to see if I know anybody else, but I don't. So maybe I'm up here and I'm only talking maybe very self-centered and selfish, but I don't know who benefits from anything that you're all doing or not doing. But can we all please just keep our Clinton Village neat, secure, and safe as it is? Thank you.
17, D-E-B-I-T-A, 17 Halsted Street. So,
Just want to give the testimony you're about to give us the truth, and nothing but the truth.
I do. So to echo what everyone has been saying tonight, and I'm sure other nights, there are a lot of concerns about how this could impact the community, the safety, the environment. Specifically, I'd like to touch on the issue with the flood, with flooding. It's serious. I am actually here representing the Board of Trustees at the Red Mill Museum Village. The Red Mill has been there since 1810 and is standing. But with these last two storms, it was affected. The grounds were flooded. As a matter of fact, we've spent the last couple of years raising money, as I'm sure many of you know, to replace the water wheel on the Red Mill. And that water wheel was there for about 70 years. And then it was just disintegrating, had to be replaced. So we've been raising money to do that. We just did. It was replaced in 2020. Well, guess what happened? As a result, most likely from the flooding, we've got all this debris stuck in the gear, or I'm not a mechanic, but within the workings of the wheel that's been causing problems, and we had to like stop, and it has to be repaired. It's really shocking. I mean, I think that's a really good example of just how different things are with regard to rainwater, floodwaters. And this is coming from a couple of days of rain, not from a hurricane. We've never seen that before. So I think I'd also like to say that town of Clinton is a very wonderful community. People are welcoming. I see a lot of familiar faces out here. I've been here since 2010, and it's, we welcome people. We welcome people all the time. So welcome to you. But there's also a pact. It's part of a relationship, right? There's give and take. There's what are you bringing? And to be a good neighbor. And being a good neighbor, you're not doing your job if you're talking about adding, I can't even imagine what amount of impervious coverage you can actually add to this area that wouldn't affect everything downtown. And this is an historic town. This isn't, it's different. It's a very unique place, and history is right up there with the nature and with the solitude and the serenity and all of those things that people have decided to live here for. It brings business, it helps business. The museums, the Red Mill Museum Village and the Hunterdon Art Museum bring a lot of people to town and help the businesses in town flourish. The idea that actually both museums suffered terribly over that last storm, and that was a couple of days of rain, and those are the museums. There were volunteers to help and clear it up. It was insane what we saw. But then, you've got neighbors here too whose houses get flooded from this same problem. And it just is not gonna go away, certainly by adding more asphalt and impervious space. So those are my comments, and I hope that the board and the council will take that into consideration.
I do. So I just wanted to revisit some things that were said at the last meeting. There was a couple of situations in which we were told that there would be recourse if something bad happened. And it's something that I think it's important to realize that when the horse is out of the barn, the horse is out of the barn. Getting it back in is problematic, particularly in a circumstance like this. So as I look across the river and I see what after the last meeting was a big white open field ripe for some sort of recreational activity, some sort of opportunity for people to go spend some time, I thought to myself, that'd be really nice if it stayed like that. And I wonder how hard folks have thought about the reality of the fact that if we get ourselves so far into this situation that the only way to dig ourselves out of it is to pursue legal means, it's probably not a great idea. Aside from all of the other issues, clearly we are getting much more intense rainfalls. They're happening in a very tight time frame, and mitigating that is problematic. And I guess the question will become, how many times will people who are impacted by the flooding have to clean up before they completely lose hope and leave town? It's just kind of disrespectful to go into a situation like this and not take that into account. So I'm new to town, but my family's been here for a long time, and I think it's a great place. They welcomed me and my wife to come to town when they found out we were here. They're very excited, and so are we. And I want to continue that excitement. And I want to continue to be a good neighbor. Thanks.
You swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes. Bill Misko, 146 Center Street. So last week, I talked about being grandfathered in for the last month. I did a little bit of research. I found State Statute 40, Section 18-2, and it says any municipality may make, amend, repeal, and enforce such other ordinances, regulations, rules, and bylaws not contrary to the laws of the state or the United States as it may deem necessary and proper for the good government, order, and protection of persons and property, and for the preservation of the public health, safety, and welfare of the municipality and its inhabitants, and as may be necessary to carry into effect the powers and duties conferred and imposed by this subtitle or by any law. I think that we are asking the developer to develop this project under the current flood and stormwater management codes. I don't think this ask is not contrary to the rules of this state. In fact, it is exactly consistent with what the state has determined based on science and data. The mere fact that there is a loophole in place to determine based on place to allow for major development using outdated codes knowingly puts health and safety of the residents of this town at risk. The Town of Clinton Stormwater Prevention Plan specifically says the stormwater management ordinance shall reduce artificially induced flood damages to public health, life, and property, minimize increased stormwater runoff rates and volumes, minimize the deterioration of existing structures that would result from increased rates of stormwater runoff, amongst other things. The town's ordinance clearly commits to a reduction in stormwater damage. Allowing this project to move forward, going against the data and under outdated codes, goes against everything our ordinances and stormwater prevention plans stand for. And I say again, knowingly puts the health and safety of this community at risk. So I'm asking the board to deny this application effective immediately and require the project going forward to abide by the current flood and stormwater management codes, which I remind you were put in place by the state because the science and data said the old codes were not doing enough.
Your name and address for next week.
David Wyant, 78 Center Street. I was sworn previously.
I'm gonna just swear you again, because I just said that for the others.
I like to swear.
So do I. Do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank you. Last week, to follow up on Will's comment, I had asked a question about whether or not the endangered species permit required reapplication. I think you said that, Kyle, you said that you were going to look into that.
Yeah, they're gonna have to document the location, which they submitted a plan that shows the new nest is actually farther north than the existing one. So the expectation is it's not gonna change any of it, but they're gonna have to confirm that with the Islands Council, which is where the conditions of Fish and Wildlife were implemented.
Thank you for that.
Sure.
So, over 20 years ago, I sat on the planning board that was looking at the same piece of property as we considered whether or not a Home Depot should be there. And a few things are the same. Mr. Clerico is still here. Other than that, I think the entire board is new. The other thing that hasn't changed, though, is the impassioned response from the community. I don't think it's solely a result of Howie's throwdown at the first meeting. But Mr. Apgar, you came up and had a short cup of coffee with our planning board sometime after the Moebus, I believe.
I was here for 9 years, actually.
A long cup of coffee. In any case, the big difference between that application and this one, as far as I can tell, is that the zoning has changed and the planner is bringing essentially a plan that complies with the new zoning. I may be mistaken. But the one thing that doesn't change is the board's responsibility to health and welfare of the town, and the board's responsibility to make sure that the I's are dotted and the T's are crossed, because the only thing that we can hold the developer to, or any subsequent developer to, is the agreement that you craft here. So I would hope that as you move forward, that you would incorporate all of the thoughts and the ideas that have been brought forward, and regarding lighting and landscaping, runoff, if you do move forward with the plan.
I know Mr. DeVita has something he needs to say,
Yes.
hopefully.
To avoid any appearance of any conflicts of interest because my wife spoke, I'm gonna have to recuse myself from this vote.
Thank God.
I know, sorry guys. I'm not.
You all had a lot of opportunity to express your feelings about this. I am a longtime resident. My family's been here since 1730. I've lived in the town of Clinton since 1961, or thereabouts, hybrid for a while. I'm very familiar with this place. My mother taught at Clinton High School in 1951. My mother went to, and her twin brother went to Clinton High School and Clinton Elementary School. Actually, you didn't have an elementary school then. They had to walk to Franklin Township. So, well, now, just a couple of technical things. The bald eagles that come up from the comments. All right, the second nest has been identified. Mr. Ingram's office were able to locate it, and it's been plotted, and as Mr. Kyle said, it's been shown on the plans. That is something that has to be reviewed by Fish and Wildlife and Highlands. And again, it's north of where the present one is. It won't affect the boundary. We don't believe that it will affect the boundary lines. But again, that's just a timing thing. We're not allowed to build or do construction during certain periods of time. Okay, the big thing that you're all talking about is,
Sorry.
can you not hear?
Yeah, it's slipping on you.
Many concerns were raised regarding flooding for those who live and work along or nearby to the South Branch. We do not dispute any of your concerns or the severity of the flooding that the residents have experienced. Clinton is a town on the river. Clinton has houses on the river. My aunt and uncle lived at 2 Center Street in the 30s, right after they got married. They got flood all the time. It's not something new. It's not something that has anything to do with global warming or rainflow generation. It's just part of.
There's no flood now.
Okay, well, the properties that are on River Road, that are on Center Street, or on Halsted Street, and that back up to Center Street, they are in flood zones. You're gonna get flooding. Probably most of you have flood insurance. You knew that when you bought your house, all right? All right, one of the things, and Mr. Ingram talked about this for 4 meetings, okay? The stormwater runoff, even though we are not using the most current standards, the stormwater runoff, and he testified to this, and your professionals have not disputed it, we are required by New Jersey law to reduce the existing flow of water coming off of that property and into the river. And the detention basin is designed to do that. Nothing will be exacerbated by this project. In fact, it's going to be made better. You can believe me if you like, but Mr. Ingram is an engineer. Mr. Clerico has been an engineer for 70 years. At least. And the calculations that we submitted are accurate, and they comply with the law. They're not going to make it worse. If anything, they're going to make it better. I have a brief closing, and I'll be joined tonight by our co-counsel, Mr. Forio Vante. That's affordable housing.
So don't say.
That this property is included in the town's fair share plan. and this project complies with the ordinance. Your town council, don't be mad at I do remember Twin Ponds testified to it.
It's on the property. Let's get on with it.
Of Clinton reach. So, we have submitted plans. They've been reviewed by your professionals many times. cross-examined, and you got your opportunity to ask them questions.
As Mr. Apgar noted, my name is Matthew Fioravanti. I'm an attorney with the law firm of Giordano, Heller, and Ciesla, based in Red Bank. We have been recently retained by the applicant in connection with this application here tonight. And your mayor is correct. This town has done what the Supreme Court told every town in New Jersey to do. In 2015, go to court and say, here's our obligation, number of units, that obligation, and it does have its origins in the New Jersey Constitution. And here's how. project would be used towards satisfying town of Clinton's affordable, long time ago, October of 2018. And it's important to emphasize that because of that settlement agreement, this is not your typical subdivision and preliminary site plan application where it's just, we take the NLUL, which is is a contractual the granting of this obligation is a contractual obligation by this board. This board, signed by the mayor and the chairman back in October of 2018, agreed not only to, and also 10 units that the town is going to use towards its affordable housing obligation. It's also important to emphasize that it's not just this agreement that's relevant for tonight. What happened agreement, and we believe that it is. So I'm not here to threaten the board or the members of the public with litigation, but I am here to educate the board as to the reality that this board put a court-ordered obligation to review this application through the prism of this settlement agreement to satisfy the town's affordable housing litigation. So with that, I will give it back to Mr. Apgar so he can
Thank you.
finalize his closing. Thank you.
Presentation about the agreement, which some aspects I certainly agree with you. I just wanted to clarify one of the things that you indicated. In section 3, where you read about the land use board being a signatory and a party to the agreement, and I agree that that their role is they endorse the agreement, but the section you're reading from relates to subdivision
Correct.
approval. And the obligation that the board has contractually is to grant subdivision approval.
That's right, you're correct that that specific section does talk about subdivision approval. But it's our position that to read that agreement narrowly, just that we're only gonna agree to accommodate a subdivision application would defeat the spirit and intent of this entire agreement, more specifically section 9, which is titled Municipal Obligation to Cooperate.
In my own summary to the board, because you guys went first, was certainly that this board has an obligation to cooperate under this agreement. So certainly I would agree with you that they agreed to endorse the agreement, they agreed to cooperate. But with regard to having an obligation to approve, that is under the subdivision approval section. And that separately under section 6, they list other approvals, including site plan, where they just list the approvals and the same obligation to approve is not specifically listed there.
Right, yeah,
Okay.
that, like I said,
Okay.
this is why the board has competent counsel to advise them. We respectfully would disagree with that for the reasons I said. I'm not gonna get into a legal
No, and I
discussion,
don't
but
want to get into,
certainly.
right, because I think the understanding is that the board is supposed to cooperate, but from an obligation standpoint, I read that as having, the obligation to grant subdivision contractually, and then certainly there was an obligation to cooperate, they endorsed the agreement, that's how I read that. I wish I had the opportunity to provide my summary first. I understand that you guys wanted to go first, we just didn't have, that's the way it went, but, I mean, I can re-summarize what I was gonna say, it's not terribly different, except for the fact that I wouldn't have, I can re-go through if the board would like me to go through what I was gonna say, or, we can have. Yes, please. Yes, okay.
Yeah, we'd like to hear that.
Okay.
Can you use the microphone?
Oh.
I got it.
Municipalities in the state, the town of Clinton filed a declaratory judgment action in Superior Court relative to its obligations to provide a reasonable opportunity for development of affordable housing. Clinton Moebus, 34, was an intervener in that declaratory judgment action. In an effort to settle the litigation with Clinton Moebus and with Fair Share Housing Center, an advocate throughout the state of New Jersey on behalf of affordable housing, and in an effort to address its affordable housing obligation, the town and the land use board entered into a settlement with Clinton Moebus to be approved by the court. The settlement provides that Clinton Moebus seeks to develop this subject property as a mixed-use project containing commercial development along Route 31 and residential development along the remainder of the property with a 10-unit affordable set-aside to be constructed off-site. Through such development, it will assist Clinton in its efforts to meet the town's affordable housing obligation in connection with the filed declaratory judgment action. In connection with the settlement, the town had the obligation to adopt new zoning for the property. In addition, the land use board has, in essence, under the agreement, an obligation to grant approval of the subdivision to avoid for subdivision relief in connection with the settlement agreement, and was approved, but the subdivision was never perfected. The land use board also has an obligation to cooperate with the town and Clinton Moebus in securing its other approvals. Clinton Moebus had a number of other obligations to fulfill as well. In sum, the affordable housing units which are to be developed in connection with the proposed development here, albeit at a different location, were stipulated to and approved by the court as part of the town's affordable housing plan. And this board has certain obligations pursuant to the settlement to see that it does not interfere with the development or act uncooperatively.
No, I'm really loud. So, sorry. We've heard testimony from the professionals representing the applicant and testimony from residents and interested parties. There are several points I'd like to make. The first is this project first came about in 2015 when the owner posted online renderings of a development that included 247 garden apartments and 5 pad sites. without ever coming to the town. We then spent several years in court negotiating with the developer in fair share housing for the town to meet its affordable housing obligation. Second, the town attempted to purchase the music hall property to address its obligation through a 100% affordable project. Because the town is required to do all business in public, the music hall property was purchased from under us by the owner of the Moebus property.
Thank you.
Third, after several years in the courts, a settlement was reached and approved by the court in October of 2018. The owner would be allowed 3 pad sites, 56 for-sale townhomes, property dedicated to the town for open space, and the affordable obligation as an age-restricted project built on the music hall property. All 3 parties to the settlement had certain obligations to meet. The town had to adopt a zoning ordinance to enable the development. The owner had to meet certain time requirements and develop a plan to meet the requirements of the settlement and ordinances. It also had to obtain all required approvals, including outside agency approvals from Highlands, NJDEP, and NJDOT. The Land Use Board also had certain obligations imposed. As Katie said, the owner applicant initially applied for the subdivision approval in connection with the settlement agreement, but never perfected that subdivision approval. They let that approval lapse. So from a timeline perspective, it is not in compliance with the settlement agreement by the owner. The subdivision request was then brought as part of this application along with the site plan request. It was amended and modified several times by the applicant before the board had a chance to substantively review, review the application. The agreement bound this board to approve the subdivision application. Our agreement did not bind this board to approve a particular site plan. While we are parties to the agreement and agreed to endorse the development of the property, there was no obligation to approve the site plan. The applicant was required to apply to this board for the approvals and go through the application process. This board has listened to all of the testimony of the applicants and its professionals. It's also considered and weighed heavily the comments of the members of the public. We are bound to consider the terms of the settlement agreement that the court has approved. I also feel that there were comments made that very much relate to the public health, safety, and welfare of this community, which have to be taken into account. With that, I would like to make 2 motions on the aspects of this application. The first motion is to approve the preliminary and final subdivision. Katie, are there any conditions related to the subdivision to add?
Yes, so as to the subdivision, the conditions that I have relative to that, there is 1 variance that would have to be granted associated with the subdivision. That's a request from section 8856 1B for minimum lot area where 15 acres is required and 9.1 acres is proposed for lot 32.02, I believe. And in addition, the portion of the property not developed and referenced during hearing shall be donated to Clinton and deed restricted as public open space. The applicant shall be subject to an access easement of 30 feet from Route 31. All of the other development related requirements of the settlement agreement shall be incorporated, and any conditions of comments on conditions related to subdivision as set forth in the memos of Mr. Clarico and Mr. Kyle and any other town officials. That's what I have relative to subdivision.
Motion with Katie's conditions.
In a second, you can have discussion.
You want to, so, so we'll look for a second, and then we're gonna just have a little discussion about the, what the motion is about?
Second, this is just
The subdivision.
I think the board should be heard before the second is granted.
On the motion for the site plan?
Yes.
Subdivision.
A subdivision, rather?
Yes.
Typically, you would ask a motion and a second, and then you can go, and then you discuss. So there's been a motion and a second, so now we can discuss it before there's a vote. There's no vote yet.
I've had a problem with several things with this process that we've gone through for a year and a half. The fact that we're gonna put up 56 townhomes on the Moebus tract, but that can't get going until the other site has been acquired and plans submitted and approved for that. So Where's that? I haven't seen any paperwork for that development. I have a problem with the fact that this agreement was signed in 2018. It's 2024. A lot of things change. There was originally a subdivision agreement that was agreed upon, and allegedly other things along with it that in fact are not the case. The phasing that was used in the presentation is ambiguous and cloudy. I mean, you're gonna develop things for the 3 commercial pods, and we don't know who those tenants are. Allegedly, one of them is a fast food place, but we're supposed to have a gas station, a food store. Who are they? Where are they? What requirements are they going to have? What requirements will they need in order to comply with what we want in the town? We don't have a DOT permit yet. The whole thing is, in my opinion, is not well put together. And it's hard for me to support it for that reason. The flooding goes without saying. I've lived in this town since 2008, and I've watched the flooding increase over time. It's hard for me to comprehend that there's somehow or other going to be water on top of a hill that flows downhill in sheet flooding, and somehow we're gonna take a lot of impervious cover and put that on top of the hill, and that water is going to stay up there. And in all deference to engineering, I don't know how water stays uphill. And frankly, I have difficulty supporting this.
What he just said, I would echo. I mean, I know the road to hell is paved with good intentions. It's getting really friggin' hot in here, right? It's getting real hot. This has been going on since 1975. I was just asking Jim about, he was a reporter covering things, and at the time he said there was a lot of uproar. And you know, I know how he didn't mean that, and I know what you meant, and the town of Clinton's done a great job. And doing the right things, and Janice and the council and everyone has done the right thing, but I'm a little confused. I'm confused just by what you said and then what was just mentioned there. What are we obligated to do right now at this point between the subdivision and what the settlement is?
The motion is just on the subdivision.
This first motion is just on the subdivision.
Which means?
This was the division, they're taking the 1 lot into 3 lots.
Does that mean that all we've heard about for the last several months, we're not voting on that,
No,
we're
it
just
doesn't mean
voting
that.
on the subdivision?
It doesn't mean that.
It's gonna be
What-
2 different votes,
It doesn't
right?
mean that at all. It just means that the mayor decided to, she went first, so she decided to.
Make it 2 separate motions.
I believe she's gonna make a separate motion, because she said I have 2 motions to make. So I think she's going to make I believe, I don't wanna speak for her, she's gonna make a separate motion as to the preliminary site plan aspect of the application.
In that
Again, I
way,
don't
I
wanna
will
speak for her.
support the motion for the subdivision.
This is the 3rd major residential development we've seen in the last few years. And it's a symptom of what's happening in the state and what must happen in the state. Some of it's voluntary, and that you're happy to have somebody come to town. And another reason is that you're obligated to do fair share housing. Doing it the way it was set out, we should stick with that as far as we can, because it's gotta be done anyway. It's gonna happen, so. It might also make sense to think of this group as the devil that you know, as opposed to some other person who come in behind it who would be less agreeable or amenable to suggestion. So I think we should go ahead and do the subdivision.
I agree with going forward with the subdivision as part of what the settlement was, and then going as a second motion, then discussing further the agreements of the layout of the land and any other possibilities we had to legally support and what was in our settlement.
So when we signed the affordable housing agreement, so my signature's on that, so I will support the subdivision in accord.
Mr. Smith?
Yes.
Ms. Janine?
Yes.
Mr. Levson?
Yes.
Mr. Carberry?
Yes.
Mr. Biacco?
Yes.
Mr. Snyder?
Yes.
Mr. Saylor?
Yes.
All right. So before I make the second motion, I would like to state, I understand my obligations as mayor. And I have an obligation to the residents of this community to ensure their health and public safety. It's a responsibility I take very seriously. I also have an obligation to protect the town legally. Yes, that does mean property owners have rights as well. But understand this, the town and land use board entered into an agreement with an applicant to endorse the development of the property as described in that agreement. This was approved by the court and prevented further litigation and potentially other impactful results. We also made clear that we expected the property owner to do all possible good, to be a good neighbor and ensure the well-being of our community. While the applicant can couch its position however it would like, but the applicant heard all the passionate testimony last month and waited until Friday evening before our hearing to send a letter that told us our obligations and to educate us, should not be constituted as a threat, and to call you if there are any questions. I've been doing this a long time. We're not stupid individuals here, and even though you seem to think so, and you should also know that I don't take kindly to threats made against the residents or the individuals on this board who voluntarily serve this board. This is a community that people have made their home and have asked you to understand the fear of damage and destruction of their property based on your plans. I make a motion to approve the preliminary site plan application. I have my own conditions to add, but first, Katie, I know you have conditions to include.
Okay, so
9:30.
there is one variance associated with the preliminary site plan, that's section 8062C1, where there's one loading space measuring 40 feet by 60 feet that would be required, and that's not provided for the fast food restaurant. There were two variances for signage referenced in our planner's memo. However, the board was not provided with the signage plan or any details regarding signage, so those would, if this went forward, that those would be deferred to final site plan and not included as part of this motion, in my opinion. As to the specific conditions that were covered over the course of the hearing process, and there may be some others. This was my initial review. I will do a subsequent review, but the initial conditions that I have are that the applicant shall construct 10 affordable housing units off-site at 23 West Main Street, which meet the requirements of the settlement agreement as to the affordable housing requirements and the historical preservation requirements. Construction of the residential units on site, on that site shall be in accordance, the subject site shall be in accordance with the settlement agreement, in that COs for only 28 of the 56 units will be issued prior to constructing and obtaining COs for the 10 affordable units. All their development-related requirements of the settlement agreement shall be incorporated by reference. Emergency and pedestrian access only can be provided by a central avenue pursuant to an access easement with primary access by Route 31. The portion of the property located between the residential development and George's Place shall be deed restricted as an open space common element of the residential community. The portion of the property located west of the residential development, residential development and adjacent to the waterway, and the portion of the property located between the residential development and Central Avenue shall be deed restricted as open space available to the public. The applicant shall be responsible for making any required applications for sewer and or water reservation. Specific property issues as to 19 George's Place, there shall be planting of lower planting material for visibility of the trees in the distance. As to 34 George's, the applicant shall keep as much of the vegetation as possible, install evergreens, and provide a 6-foot fence on the north side. As to 93 Center Street, the applicant shall plant extra evergreen trees for buffering. The applicant will review potential for adding a French drain or other improvements to prevent drainage issues, and they will meet with the property owner on the along with the grading of the property. As to 25 George's Place, the applicant will plant a lower level of evergreen shrubs to add a second layer of buffering. The applicant will add EV spaces and make ready spaces to be added If they have not done so already, they will submit a fire circulation plan to the satisfaction of the fire marshal. Fire hydrants must be active before any wood is delivered to the site. They act to add significant landscaping between the development and the cemetery and add a fence along the cemetery line. Adjustments to the landscaping will be made in the field in accordance with meetings with the planner and neighboring residents. Applicant will meet with the homeowners in the field, particularly along George's Place. There'll be a 2-year maintenance bond on landscaping. Homeowner documents will require that buffering plantings remain in place. Landscaping shall match the site plan approval and per the resident discussions and stipulations with the applicant's engineer and the board's professional team. There shall be monitoring about vibration impacts in place with regard to certain homes within proximity to the construction area along George's and Center. The applicant shall provide info on what monitoring system it intends to use with the township engineer. There shall be monitoring of vibration impacts in place with regard to sewer and water mains in proximity to the development. There shall be confirmation and review of phasing with Mr. Clarico to his satisfaction before it is implemented. There shall be a meeting with the fire marshal to review fire-related items to his satisfaction, and the applicant will stake the corners of the property. Construction time limits shall be in place due to buffer restrictions and the 2 Eagles Nest. Documenting of the second Eagles Nest with the Highlands Council and NJDP will be implemented as required. Outside agency approvals will be obtained, including from NJDOT, NJDEP, County Hunterdon Planning Board, and the Soil Conservation District, among others. Construction shall occur on site in accordance with the settlement and requirement to construct the affordable housing units off-site, and the applicant shall comply with the conditions set forth in the memos of Mr. Clarico, Mr. Kyle, the fire marshal, and any other town official who provided one.
Address the eagles, but the applicant will go back to the DEP and Highlands to prove that the additional eagle's nest has been accounted for, and the requirements that the DEP and the Highlands established initially address the second nest, and if not, what will be done to ensure the protection of the second nest. The stormwater design is based on rules from 2 versions ago. The next 2 conditions are that the stormwater plans are redesigned to address and incorporate the green infrastructure requirements and the enhanced rainfall requirements of the most recent stormwater regulations which have been adopted. When this original agreement was completed, we had not experienced the flooding that we have seen recently, and your project should meet the current stormwater obligations in this regard. That's my motion.
I'd like to see what has been just described to me in black and white before I make up my mind as to whether or not it should be approved.
Everything Katie just read?
Yes.
Mr. Carver, could I just, one thing, when you were asking your questions about the subdivision, okay, this is preliminary final site plan.
Everybody out what's going on and what's not going on.
Oh, absolutely. I was just trying to.
Yeah, this feels a little coercive to me. I'm not sure that, does this cross any lines?
No, I was just trying to explain something.
But that's what our.
Yeah, the board is deliberating right now. It's not really your turn to talk to the board members, so. If there's a question, our board members can ask our counsel, but you should not be addressing the board members during deliberations.
I don't want to use the word agree with Howard in the sense that this is preliminary site plan. There are certain things in terms of when an applicant applies for preliminary that have to be addressed, and then when they come back at final, the final details of a plan, including things like which tenant it is or those kind of things, can be finalized at final. And I would also argue that if things substantially differ from what is approved at a preliminary site plan, that the applicant will be required to come in for amended preliminary and final at the same time.
I understand, and I appreciate
And I know
that.
you understand, because I know that this board has dealt with site plans on numerous occasions, so I know that you understand all the standards.
We've
for
had
that.
10 meetings working on preliminary site plan approval, and we still can't agree on what it is.
Well, I mean, I don't know, like, if an applicant complies with the ordinance.
Didn't you just read language of a change in ordinance?
No, I read conditions that I picked up during the course of the hearing that the applicant either stipulated to, was part of a settlement agreement, that were part of professional memoranda, that were all site plan related, but they were not ordinance deviations. The only ordinance deviation that was at issue at this point is related to the one loading space at this point.
Changes in the plans and that the engagement of our professionals was really valuable.
They shape pieces of the project for sure. Correct. They shape how the ultimate development is going to be, and how the next set of plans, when they come back for final, how the next set of plans is going to look, it should reflect every aspect of what I just read, and what's going to be, if this board acted favorably, and this was in a resolution, the next set of plans would have to reflect those conditions.
Including the mayor's?
If you incorporate the mayor's conditions, yes, then that would reflect that.
They would have to, and somewhat they've already agreed during the testimony that, I mean, Wayne and everybody there was like, okay, yeah, we'll consider that. This is the first
Right, I
time that the
mean-
mayor has introduced the new stormwater, so they have to deliberate that as well, correct?
They would deliberate that
And
as
then
well.
they would come back, if they agree to do that,
If they agree to do that.
it'll come back in the
Right.
final.
These other elements have already been part of the record.
Sure.
Right.
And agreed to, right?
Right.
Are we able to see the final plans before the final approval of this, or it's, I know
So
we
the
don't
two were
have to
not-
see before the preliminary, we don't have to see, but before the final?
Yeah, so the two were not linked that way in the settlement agreement.
Because it's offsite.
Our check is that they can't get more than 28 COs on townhomes until those units are issued COs.
Have the plans for that development come forward?
They've not been filed, no.
I'm gonna no way to make them bring this forward.
No.
They weren't part of.
Not at this point, but again, when we get to a certain point, yes.
What is that?
In the 28er bill.
Right.
I'm thankful that the mayor incorporated that into her statement, and I fully support that being a condition of approval.
Okay.
I live in a house that floods, I get it.
Wedge?
Yes.
Mr. Carberry?
No.
Wait, okay, so, okay.
Ms. Deneen? Yes. Mr. Lupson?
Yes.
Mr. Smith?
Yes.
Mr. Beato?
Yes.
Mr. Snyder?
Yes.
Mr. Saylor?
Yes.